Welcome to the monthly truck stop webinars. These stops are presented the second Thursday of each month at 2 p.m. Eastern Time. These webinars are open to the members of the Motor Carrier Insurance Education Foundation. These webinars are presented as industry updates for informational purposes only and do not qualify for state CE credits. If you're seeking CE credits, visit our website, MCIEF.org, or email prs@mcief.org. They will give you the information about webinars that do qualify for state CE retail agent credit. If you have any questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar by email. If you experience audio problems, please contact us with a note in the chat window or call our 800 number, 741-484. We'll attempt to correct the problem as soon as possible. Once these webinars are over, they will be posted on our website to review later. We're going to call it additional insured endorsement versus no insurance endorsement. It's going to be presented by Fred Marcinak and Lesesne Phillips, Moseley, Marcinak Law Group, LLC. And we got their webinar information here, as well as myself. What started me talking to them about this is I got a call from an agent, about 6 months ago, that said a broker has refused to give a load to one of my insurers because they would not accept ISO's designated insured endorsement and must have an additional insured endorsement. Can you call and explain the difference? So I called him back and we talked about it, but the broker already knew all he wanted to know. Designated insured endorsement does not provide defense, and we must have additional insured endorsement. That's what they told me. Ask him if he would send me a copy of the additional insured endorsement he would accept, and I would send him the differences and confirm that the designated insured endorsement would not meet all his requirements. So instead of sending it to me, he just hung up. He knew everything he wanted to know. The broker lost the service of motor carrier because he, meaning the broker, did not understand insurance. The insured motor carrier lost a load because the broker did not understand insurance. So I called Rob Moseley and said, help. After much work with the Moseley Marcinak LLC, Rob and Fred and Lesesne, with my input, we have prepared a white paper that can be provided to all interest parties to explain what brokers, shippers ask for and how insurance will meet these requirements. Most of you know about the Moseley Marcinak firm. They've been a part of presenting at our annual conference, and we relied heavily on them for information during the year. But let's take a minute to introduce you and talk about your firm. Tell us a little about Fred and Lesesne.
Okay, Tommy, thanks. We appreciate it. Appreciate the opportunity to participate in the webinar. I think a lot of people who watch the webinar will probably know Rob Moseley or me. We've worked with Tommy over the years at the annual conference and at different events. But Rob and I both have been practicing in the area of transportation law for over 15 years. Rob he'll fuss at me for telling you this, but he's coming up on over 25 years of practicing in transportation law, and I've been doing it for about 15 years. And we started Moseley Marcinak Law Firm about a year ago. So Tommy, it'll actually be our 1-year anniversary in 2 days on April 1st. So we'll be celebrating the 1-year anniversary. And I guess by the time your folks hear this, we'll have done that by then. So we're coming up on 1 year anniversary, and we started the firm to focus on transportation. So we represent brokers, we represent motor carriers, we represent insurers, we represent insurance agents, we represent freight forwarders, and anyone who has anything to do with transportation and logistics. And so that's what we do. And we've worked with you a lot on the insurance issues that are particular for transportation companies, and so we're glad to do that. And Lesesne Phillips, who's joining us today, he joined our firm a year ago and has been an important part of working on this issue that we're going to talk about today.
Brad,
yes,
thank
you for having me.
Thank you for being here. let's talk about this. And this is work that Sam and I put a lot of work into, and that Fred has put his 2 cents in to make sure that we're coming to the right approach. The first thing we want to remind people of is that the broker shipper needs to make sure the motor carrier has the right authority to haul the load. They check in license insurance, and they see they have the license, meaning the authority to haul the load, but then they look at the 91X. And Fred, you weren't there, but Rob and I did a webinar for the expediting industry in Nashville about 3 years ago. And that room was set full of brokers, and we went through all that stuff about last mile delivery. And one of the brokers said, well, all we rely on to make sure they got a 91X. And Rob and I looked at each other and said, whoa. Because what brokers don't understand is the 91X does not give them any protection. Only there to protect the public. And so if there is no coverage in the policy, meaning the vehicles that are used are not scheduled in the policy, are not qualified as a covered auto, there could be a suit. And in those cases, the broker and shipper could be named in the suit, but they get no defense. And if the judgment is also against the broker and shipper as well as the motor carrier, that judgment is not to be paid by the insurance company 91X, because all they're obligated to pay is the judgment against the broker. Fred, do you run into this problem sometimes where the broker doesn't dig deep enough and get a proper certificate from the regional agent to make sure that they do have the insurance requirements that they need?
Yeah, it's a common issue, and the broker looks at that insurance filing on the FMCSA website and says, well, they've got insurance, that's good enough, but you're right, unless they dig deeper, there may be insurance there that may help to ward off a claim, because they know there's $1 million there that could be made available, or $750,000 by the filing, but probably ultimately $1 million that would be made available to pay out to the public. But if it's a catastrophic loss and the plaintiff wants beyond that $750,000 or $1 million, they're going to come after that broker. And if all you have is the filing, there's not going to be any protection for the broker under that insurance policy. Yeah, because if the only time the filing comes in play is when there's no coverage. And when there's no coverage and the filing is just there to protect the public or the MCS 90 endorsement, they don't understand that doesn't give them any protection. That doesn't give them defense. In fact, the reason I point this out, Fred, I think that broker I was talking to earlier in my introduction misunderstood the difference in what 91X has and a proper certificate of insurance proving coverage. Because when he told me that the designated insurance endorsement does not provide defense, I have no idea where he got that information from. But in case of the 91X and there's no insurance in place, you rely on 91X, that doesn't provide defense. So I brought this up when we put this together just to get rid of that myth, because I think that could have been some of his misunderstanding. So why do brokers and shippers want to know the motor carrier they provide a load to have the right insurance? Well, Fred, you just talked about it, because they're looking for their first defense, right? And when you get, and you represent motor carriers sometimes as well as brokers, when you get the claim coming in, don't a lot of times you then, in the complaint, depending on the wording, then render that back to the motor carrier insurance company who they provide the load to? No, what I'm saying is the reason the broker and shipper want to know the right coverage is that they hope that if the suit occurs on a crash that happens by a truck they gave a load to, that they get some of their first insurance protection from the insurance carrier or insurance policy on that truck they gave a load to. So they want to know they have the right insurance in place, also with cargo and other things. So that's a concern every broker and shipper should want to make sure that they have to get them some protection for besides their own, but on the trucking coverage of the vehicle that caused the crash. Yeah, I that's exactly right. And what the broker or the shipper wants to do, whoever hired that motor carrier, what they want to do is push that insurance coverage and that liability for that loss, the financial impact of that, down the chain as much as they can. So if a shipper contracts with a broker, the shipper wants to push it onto the broker. And if the broker contracts with a carrier, the broker wants to push it down to the carrier. So you'll see provisions in contracts that the carrier has to provide insurance that is primary and non-contributory, and it's the broker's insurance is excess, and they may say that a dozen different ways in a contract, but ultimately what they're trying to do is to push that financial loss down to the carrier and off of the broker.
As much as possible, yeah. And so motor carriers and insurance providers understand they must provide proof of coverage for the right insurance for the motor carrier to call a load, just like that example that I talked about earlier to kick this thing off. And when we talk about this, as far as the people who are listening to us, who are the insurance providers, which most of y'all will, some of you might be listening who are motor carriers to understand that the shipper provides this information or the broker about what insurance are required, and that this is a part of what the insurance agent and the insurance provider needs to walk through as far as a part of providing the coverage that the motor carrier needs. It's not only just the policy, it's can you meet all these requirements? Because I had a situation one time where the insurance carrier was a new policy, and that it took 3 days before that new insurance carrier would give the right wording to the customer, the main customer of this motor carrier, so they can get in and start hauling loads or not. And part of that's part of these kind of discussions we have today, but just like this example you have, so often they needed that. And this is where the disconnect comes in. This is what we want to talk about, disconnect. Now, this next slide is some of these requirements are valid, but often ask for a misunderstanding in what we describe as a insurance sugar pill. Lucerne, this was your comment. Tell me where you came up with this wording.
Well, thinking about some of the requirements they asked for, we thought of the idea of an insurance sugar pill where, you know, a sugar pill you give to somebody and they take it and they think it's helping when it's actually not really doing anything, or you're deriving no benefit from what they're giving you. And so when we thought of these problems that we're addressing today, we thought of insurance sugar pill would be a good example.
It is a good example, and I hadn't thought about that analogy until you brought it up in our meeting here. I totally agree with you, because what happens is, while asking for a requirement proof of an additional insured endorsement, that's what we're going to talk about. That's the sugar pill, because that's not what you really want. The word we have here is that additional insured that we're going to drill down as we go through this process and this discussion that we have together. So we find that typically the contract scenario between a broker and a shipper and motor carrier. Before engaging in business, a broker shipper will generally require a motor carrier to provide proof of auto liability insurance. Typically, the policy is a standard ISO-based policy. This policy contains a who's insured provision, and when requested, the designated insured endorsement. I find a few policies, Fred, you deal with more policies than CERN does and see this thing, but I find that 95% of the policies in the marketplace, if not more, have an ISO basis with this who's insured provision and the designated insured endorsement available to them in most cases. A lot of carriers have proprietary endorsement that have a different name instead of designated insured endorsement. But don't you find, because you and I have done a couple coverage webinars or programs like the annual conference, don't you find that most of the insurance carriers you deal with do base their coverage on ISO policies?
Yeah, they do. That's right. And, you know, a lot of them just use the actual ISO forms, but even the ones that don't typically mimic a lot of that language. So if you see the copyright ISO at the bottom, then you know you have an ISO form that we're talking about here. But even if you don't, a lot of the language is very similar. So a lot of what we're going to say would apply to just about every auto liability policy, commercial auto liability policy that would be used for a motor carrier.
And later, when we'll talk about the sermon, I came up with this is that one of the things, if they're provided this nature endorsement, then they know that it is the standard ISO wording that we have on this next slide. And this is the wording we have. This is in the motor carriers form. This is the old truckers policy, and this is the Minnesota policy. This is the who's insured provision, and the policy terminology says who's insured. Anyone who qualifies is insured in the who's insured provision. And the paragraph C in the Minnesota policy, paragraph E or item E, and motor carriers will include this. Anyone liable for the conduct of insured described above, but only to the extent of liability. Fred, you want to explain what that means in layman's terms?
Yeah, I think it's important to talk about the fact that when what we're talking about here are when we've got, let's just say we've got a catastrophic accident and we have a claim being made against someone other than the motor carrier. So either the broker who brokered the load or the shipper who consigned the freight to the carrier, or both, maybe both. And so how do you get liability against the broker or the shipper? How do you allege that they're at fault? You know, we had a truck driver, let's say truck driver ran a red light and caused a catastrophic accident. How do we allege liability against a broker or a shipper? Well, there are really two basic ways. One is the plaintiff could allege that the broker or shipper is vicariously liable for the driver's and the carrier's conduct, which means the broker didn't do anything wrong, but because of the tight nature of the relationship between the broker and the carrier, the broker should be held legally liable for what the carrier or the driver did. The second way is if the broker is negligent, is independent negligent. If it did something wrong on its own, and that might be, for example, a negligent selection claim that they hired an unsafe carrier. And so what we're talking about here when we look at that language that you referenced is we're talking about the vicarious liability situation where the policy is going to define the broker as a quote unquote insured, meaning that the broker is entitled to a defense and indemnity under the policy if there is a vicarious liability claim being made against the broker. In other words, if the plaintiff is saying the broker should be held legally liable because based purely on the conduct of the carrier or the driver, then that policy under its basic coverage form without any endorsement is going to extend coverage to the broker or the shipper in that situation.
So this gets back to the Cern's civil sugar bill, because as Fred just described, any vicarious liability claim against the broker shipper will be covered under the ISO-based policy provision of the motor carrier because of the policy who's insured provision with or without this insured claim. This is what most people forget, Fred, and so often when we deal through this, they don't realize that it's already there. I've taught this often, and when I teach it, I talk about it as a blanket addition insured, and it's amazing even how the insurance providers don't always understand what we're providing in this area. And so this is the point that we're trying to make here. Now, what the designated insured endorsement, though, it just confirms here, because that endorsement has this language in it also. Each person or organization shown in the schedule is insured for covered auto coverage, but only to the extent that person or organization qualifies as insured under who's insured provision, meaning that do you meet that requirement already under the vicarious wording? All we're doing is confirming that by putting a name there. From a mechanical standpoint, you might not realize from the insurance standpoint, is that when we send a certificate of insurance out, most of them are based on the CORD, which is a provider certificate of insurance. It says when you have an additional insured reflected on the certificate, there must be an endorsement. This meets that requirement of the of requiring this part of it. But that does not provide any additional coverage than what's already there. It only says that it's only there to make somebody happy. And the only thing it does is the broker or the shipper do not think they're anyone. We'll put in writing they're anyone. And so often that's a disconnect that we deal with here, is that all that does is confirm the coverage that's already there in the policy. But it would be recommended to make sure you do have that wording in it to require that endorsement. Fred, would you suggest that they needed that to ask for that, and that would be reasonable?
Yeah, I mean, I think we see, I don't know that I've ever seen a broker carrier contract that has not said the carrier must name broker as a additional insured on the carrier's policy. And we've just been through why that really doesn't gain anything for the broker beyond what the broker already gets under the policy. But it's a little bit of a, Tommy, I think it's a little bit of a kind of a herd mentality that it's in every contract. So the brokers, when they write these contracts and review them, they look to see if it's in there, they want it in there, And I think there's a little bit of misconception that the brokers think that if they're an additional insured, that somehow that makes them the same as a named insured under the policy, in that they're entitled to coverage under all circumstances for whatever claims are made, that they just get insurance under that policy, or they just do it because they've seen additional insured in every policy. But you're right, it doesn't get them anything beyond what they already get in the basic coverage form. It doesn't get them coverage beyond the vicarious liability situation. And so the designated insured, the endorsement that you're referencing, which simply reconfirms the status under the basic coverage form, but puts the broker's name on it, and so makes it a little more official. That gets them everything they would want.
Right, and they get hung up on this designated versus additional, and we'll talk more about that. So explain this. So summarize this as, so the standard ISO policy with no endorsement provided to the broker shipper protect the broker shipper for being held liable for the vicarious liability. Right, Fred? That's what we just went through. So
absolutely.
Additional insured endorsement, simply to make the broker and shipper happy. I mean, they get this word additional, and I have no idea where they came up with that. Yes, I do have an idea. And this is a disconnect, and some of you know that we have relationships with ISO, and I think your firm even has done some work with ISO, having Fred, I know Rob has with Andy, trying to rewrite some of these coverage forms that are involved in it, particularly who qualifies for the use of a trailer, permissive user, that kind of stuff. But additional insured endorsement, there is one provided for the general liability policy. And that is more limited than this, because the general liability policy does not include that vicarious wording in it automatically. So this is where they came up with this part of it here. So it's just a terminology. It's the title is the only difference, but not the wording. So what everybody forgets, and I don't blame these brokers and shippers, Fred, so often they outsource this, or they have a checklist, do they not, for someone who doesn't know insurance and says, before I give a load, I've got to have these things in place. And this is where the hang-up comes up in those cases, because they're not willing to look beyond the title. I don't know how you deal or how you get advice from your people, Fred, but this is what we're trying to point out here, is it not? They need to look at exactly what it does, not just the title, the endorsement.
Yeah, I think most brokers have a what we call a carrier vetting process, and we certainly recommend that. Vetting the carriers, brokers have to do it. It's a good thing. It's a necessary thing. We help brokers design vetting processes so they know how to select carriers and which carriers should be chosen and which should not. And so every broker's got to do that. But I think what it comes down to here is, on that vetting list, there's a checkbox that says that we got an endorsement. Actually, what it comes down to at the end of the day is they got a certificate of insurance saying that the broker is an additional insured. I don't know that they normally even see the endorsement, but they see the certificate showing that they are in fact named as an additional insured, and they want to have that to be able to check that box. And when you say, well, designated insured, or you're already named, you're already entitled to all the benefits under the coverage form, the operations folks at the broker who process the vetting, they don't know what that means, and so they like seeing the so-called magic words.
Yeah, and one of the things I suggested to the Retail Agent Center, and again, you who are listening to us with insurance providers might have some, you need to walk through this with your agents, but I have always suggested that it's okay for the agent to put in the comments section when the policy is based on ISO that you, shipper, broker, who are a additional insured because of provision E or C in the motor carrier, or that it's on a policy who's insured provision. I suggest you put that in the comments section, just like you put the limits and scheduled vehicle and effective date of the policy, because that's the policy wording, right? And these certificates never come in play unless there's no coverage, and the coverage is there. Would you agree? I'm not asking you to agree with me, but do you understand that logic to do it that way?
Sure, I think that's exactly right.
So why additional insured endorsement? Just to make the broker shipper happy. The title is the only difference. You got to read beyond the title. So what I've done, and the funny thing about this, Fred, the first time we did this, and certain I put the name of the carriers. I left this out here. We just gave some 3 wordings of major insurance carriers who do have their own proprietary additional insured endorsements. This is wording from 3 major insurance carriers who run a lot of trucking coverages, who had went to the problem of filing their own additional insured endorsement. In fact, one of the carriers actually charges for this versus they give the designated insured endorsement free. We can talk about that later. But I read through these wordings, and when we read these 3 examples, we can then look at what they really mean. The first one is the person or organization is insured with respect to the such liability coverage as is afforded by the policy, but this insurance applies to said insured only as a person liable for the conduct of any insured, and then only to the extent of that liability. We also agree that the insurance provided by the endorsement will be primary of any power and only expenses prescribed on the declaration page. Fred, that's vicarious wording, is it not? Just like we said, the other actions of the insured, conduct and actions of the same wording, is it not?
That is exactly what it is. It is doing everything we've described.
The second one says, who's an insured is changed to include as an insured the personal organization shown in the schedule or in this endorsement only if they are liable for the conduct of insured shown in the who's insured provision only to the extent of that liability. Again, the only thing they almost mimic it, the designated insured wording, they just change the title of the endorsement.
Yep, it's the same thing, just said in a different way.
And the last one here is consideration of payment of additional premium listed below. The liability coverage extended to include the additional insured named herein, provided that such insurance applies only to the ownership names and use of the covered auto, and such insurance provides only to actions or omissions by you, your agents, or your employees while covered auto is being used in your business. Again, the you there is the motor carrier. So all 3 of these boil us back down to no extent coverage beyond the distance, what's already the unendorsed policy, or at least the designated insured policy. Is that the way you read these things, Fred?
Sure. Yes. It's that's exactly what they're saying. Is they're confirming that the policy extends coverage to that additional insured for in a vicarious liability situation.
I actually talk about this and different thing. In fact, these endorsements are slightly more limited than the unendorsed standard ISO policy or the designated insured endorsement. For example, if the broker requires an endorsement that is named as additional insured under any of the above endorsements, then the broker would be protected, but the shipper would not be. In comparison, the ISO with or without the designated insured endorsement protects based on anyone held liable for the conduct of the insured, not based on whether entity is listed in additional insured endorsement. In fact, Rob and I went through this in the program, and he actually said is that you can name anybody in the world named here and they'd be covered because the name is not important. It's how they're held liable for the actions of the insured, getting back to vicarious wording. And so this is where I contend any additional insured endorsement marketplace is more limited than an unendorsed ISO policy. And I think this is what we're trying to prove through here. So when the broker shipper is named in the suit following a crash caused by the truck that provided a load to, the standard ISO policy, with or without the designated insured endorsement, and any other additional insured endorsement will provide the broker shipper defense, and they will receive a release if the claim is settled within the limits of the policy, as long as the complaint is because of vicarious liability. Is this how the cases will be handled, Fred?
Yes. Yep. That is exactly right. The vicarious the policy will extend coverage based on vicarious liability, and the insurer who owes that duty. I think it's important to point out. A lot of times, Tommy, an insurer thinks about owing a duty to its named insured. The named insured has purchased the coverage, and they have a contractual relationship with the insurer, and the insurer has a duty to defend and indemnify. And I think everybody knows that. That's basic insurance 101. But what insurers have to be careful about is that where there is another party out there who is defined as an insured under the policy, the insurer owes those same duties to that other party. That under the contract that the insurer agreed to, the insurer owes the duties to defend and indemnify that other party who's defined as an insured. And that means that when it comes to resolving claims, an insurer cannot settle a claim in favor of its named insured and obtain a release for its named insured, but leave another party who's an insured out there not protected by the release. At least before the insurer does that, the insurer would need to document why it's doing that, and probably obtain permission and go through a number of steps. And that's a very important point, because I have seen even very experienced insurers in the commercial trucking market settle claims and obtain a release for the named insured, but not for another party who is an insured under the policy. And that party who's an insured has a contractual right to the insurance under the policy. So that can create a significant issue for the insurer in that situation.
And the magic term in that sometimes, Fred, is called bad faith, because they're not protecting everybody that's there. And I have also seen the same situation you have when I've gotten the case and saying how they still have this entity named in it when they should qualify as insured, why they get a release when they settle it. This happens often in those areas. And this also, if you've got brokers or shippers who are listening to this webinar, if you get named in the suit and you get a complaint, then you need to give that to the motor carriage insurance carrier. And a lot of times the motor carriage insurance carrier, would they not have an obligation, Fred, to see if it's named in there, to go ahead and contact the broker and shipper to let them know what the rights they have? Because at first, as you talked about, there could be a gray area, and we'll talk about this in a second, vicarious liability and direct liability, and it could be a reservation of rights. But wouldn't the insurance carrier itself have an obligation to then contact anybody else about that complaint that could be named in the suit, or that is named in the suit that could be qualified as insured under the policy?
Well, I don't know if I would go so far as to say in every case they have an obligation to affirmatively reach out, but I would say this. I would say that I've never seen a suit alleging liability against a broker that did not allege both vicarious liability and direct negligence against the broker. So there will oftentimes be the two mixed, but the law is, if you've got a claim in a complaint, the one claim that's covered under the policy and one that's not, then the insurer has to provide coverage, has to provide a defense for that, for all the claims. They can't say we're going to defend you on one but not on the other. But of course they would do that under reservation of rights, but they would be providing a defense. I also want to back up and say just a second, when we've seen insurers settle claims and not obtain a release for, say, a broker who's an insured under a policy, sometimes it may be that the insurer is not even aware. If you have a catastrophic loss and there's obvious negligence on the part of the carrier, an insurer comes in and quickly negotiates a policy limit settlement and says, I want to get this settled and pay policy limits and get a release and protect my insured before, while I have the opportunity to do so. Maybe they get a time limit demand from the plaintiff saying, policy limits demand, if you don't agree to the policy limits within 2 weeks, we're going to withdraw the demand and we're going to bring suit and go after your insured's personal assets. Maybe the insurer settles for policy limits. Maybe there was a broker on that shipment that the insurer didn't know about, that the shipment was brokered and the insurer never knew the broker was there, never thought about it, never investigated. And so I just wanted to clarify that I don't think insurers consciously leave out brokers, but there can be situations where a settlement occurs quickly before they realize that there are other potential insureds out there.
And there's also a situation, sometimes there's a conflict. Sometimes the insurance carrier would have to provide a separate lawyer for each person who qualifies as insured in the policy too. This sometimes happens in some of the cases when there's a conflict. So if the insurance carrier or the motor carrier cannot obtain a settlement within the limits of the policy, then the broker carrier's policy would be excess of the primary coverage provided by the insurance carrier of the motor carrier that provided a load to. This is one of the questions that we had here, Fred, that also talking about primary non-contributory. Those are magical words, as you know. And the thing that most of the people who are listening to us today know, that some brokers and shippers don't know, the auto policies say that owned autos are primary and non-owned autos are excess. So for the motor carrier who's hauling a load and that motor carrier has a crash and their broker gets named the suit, that coverage is primary for anyone who qualifies as an insured. So that coverage is primary. If the broker and shipper has coverage above the policy limits of the truck that haul the load, which they should have, contingency auto, not on auto on their own auto policies, that's always excess. And the other theory that we come up here is non-contributory. Fred, I had listened to you all, and the thing is, you can't seek contribution from an insured who that qualifies insured on the policy. So the policy also provides no contribution by that, and the policy on the broker shipper would not contribute because it's not primary, it's always excess. That's, so what we're saying, folks, is that the ISO standard policy without an endorsement provides for the broker shipper when they're hauled vicarious liable for the load on a crash caused by a vehicle they gave a load to, they are additionally insured. The coverage is primary. The coverage on the broker shipper, if they have their own, will always be excess, and it cannot seek contribution. I think that's. Do you agree with that summarization of that, Fred? I'm not asking you to agree with me because you already took exception on one thing, but I think that is important.
Yeah, I think it's common knowledge that an insurer that pays a claim under a third-party liability policy cannot seek contribution from an insured for the amounts that it had to pay out. That's why it's the difference between insurance and a bond. An insurer is not a surety that can get contribution from its principal. So you can't get it from the insured. Now, the only way you can get it from another insurer, another potential insurance policy, is if you had, say, two policies that were both primary, that were co-primary, and perhaps they would have to split the payment of that claim. But in this situation where the broker's insurer is going to be excess and the carrier's insurer is primary, then the carrier's insurer has no right to make a demand for any payment under that broker insurance policy.
That's a misunderstanding that we also don't point out here. So there is examples between being vicarious liable, though, and the broker shipper's own actions. You already mentioned one of those situations here. I came up with this one here. So in the case, the broker shipper would need their own primary coverage for their own negligent actions, and that's where it separates between the two. Fred, do you have some examples about the difference in vicarious and direct actions? You talked about the negligent hiring.
Yeah, so like I said, I don't know that I've ever seen a case against a broker that didn't allege independent negligence against the broker. So, vicarious liability, we already talked about that. So it's based on the carrier's or the driver's negligence, and the claim is that the broker controlled the shipment so much that it should be held vicariously liable. The negligent selection is an example of independent negligence on the broker, where in that situation, the argument is, well, the broker had its own negligence because let's say it selected a carrier that was not qualified to perform the transportation, then that would be independent negligence on the part of the broker. Or we've used an example of a shipper who was negligently loaded freight onto a trailer, and the negligent loading is what caused the accident. That would be negligence on the part of the shipper, not based on the carrier. And so those exposures would not be covered under the carrier's policy. The broker or the shipper would have to have its own coverage for those exposures.
Yeah, and that's no matter what. That's just insured, designated insured, whatever you have, that would not be covered in that. And that's the example I use, Fred, is that when truck runs down the highway and it's a drop and hook situation, which means that the driver did not have a chance to make sure the load was secured properly. They got a sealed container. If the truck turns over and it's the driver's negligence, then that broker or shipper would be covered under the policy, because now they're being held liable for the actions of that driver. However, if because of the load shifted or the items were misloaded and turned over, they would not qualify as insured. They must have their own coverage. And this would be sorted out at claim time, and obviously with 2 or 3 lawyers involved, that kind of stuff. But that's the difference in that part of it. The bottom line, the standard-based ISO liability policy with no endorsement makes a broker, shipper, and additional insured. Coverage provided is primary, cannot seek contribution from the insured, and the contract allows subrogation to be waived as long as the insurance contract is done beforehand. So if the broker shipper is alleged to be vicariously liable for the actions of the motor carriers, then the coverage that's going to be provided on the truck they gave the load to will always be primary. The insurance carrier cannot seek contribution, and cannot seek subrogation from that motor carrier as long as the contract, from the shipper and broker, as long as the contract is set. We got a couple of minutes left here, Fred. There's a couple other things that come up here. This is that we've been discussing auto liability. How about cargo? We had this discussion, the firm and I had this discussion a lot, and I got with you about the need to add as an additional insured a broker or shipper. My comment is that the policy itself, all cargo policies are Bailey's form, and all cargo policies make whoever qualifies as insured, but only if they're liable for the damage to the property in their care, custody, control. So by adding an additional insured, a broker or shipper, that property is never in the broker or shipper's care, custody, control, Fred. So I don't see how they would qualify as insured. In fact, if the shipper owns the goods, that would even be a problem with liability policy and might negate some coverage, because as we just went in front of you, can't be liable to yourself. I see these things happening. How do you explain to the broker and shipper about being additional insured on a cargo policy?
I think it comes from a misconception of what cargo insurance is, because there are first-party cargo coverages that are, sometimes called shipper's interest policies, inland marine type policies that provide first-party coverage for cargo. But what we're talking about with motor carriers are third-party liability type policies for cargo loss. I think the ISO form is actually called motor carrier cargo legal liability. And so the shipper certainly does not want to be an additional insured, because the shipper owns the goods. So the shipper would not be entitled to any, would not want a defense or indemnity for a cargo claim under that policy. The shipper wants to be a claimant under that policy and not the insured. The broker could conceivably want to be an insured under the policy, because sometimes a shipper, an owner of the goods, may bring a cargo claim against a broker and a carrier. But unless the policy is written with an endorsement for brokerage operations, or unless the policy is a contingent type policy written for that broker, then the policy is not going to extend coverage to the broker, even if it is named as an additional insured. So, Tommy, the only way to really address this is to to try to educate the broker and the shipper on what's happening with cargo policies.
Fred, this is exactly why we're having this. And I try to do this and hopefully getting it out for you, firm, and through the foundation, maybe get that word out. You're exactly right. Another thing is, somebody comes, well, if the broker is holding the shipper harmless for that, all cargo policies I find also have a contractual exclusion in them, which would not bring it back then. The one that I really like here is that the shipper and the broker want to be a lost payee. Again, that's what we're talking about. It's a liability policy. And so in this case, Fred, particularly if the shippers get involved in it as a lost payee, I make the comment in it that go ahead and put on the certificate of insurance, shipper, broker, if you, shipper, consignee, if you're the owner of the property, you are the lost payee. Because isn't that the definition of the legal liability policy, that we have to pay the entity who owns the goods that are damaged? That's actually the definition of lost payee, is it not?
Yeah, it is. And the only, the shipper, the owner of the goods is unless it's assigned its rights to someone else, is always going to be a lost payee. The real issue is brokers. A lot of times brokers want to be the middlemen in cargo claims. And so they want to be kind of the face of things to their customer. So when the customer has a cargo loss, a lot of times the brokers want to negotiate with the carriers and say, well, pay me, and then I'll pay the shipper and make him whole. And so maybe a broker wants to be named as a lost payee in order to get paid on a cargo loss, because maybe it's already paid its shipper customer, or it's going to pay its shipper customer. So they may want to be a lost payee. But unless they have obtained an assignment of the shipper's rights on that cargo claim, the danger for the carrier and the insurer is if a payment is made to a broker, and then for whatever reason the broker doesn't pay that over to the shipper, who ultimately owns the claim, then you have not extinguished that claim, and you still have a valid claim by the shipper there that could be made for that cargo loss.
Exactly right, Fred, and that's what I said. Push back and say, we'll name you, but only if you get a written permission from the owner of that property to allow you to be named on that, because that's the concern here. So this hour we spent, almost an hour we spent with everybody. The motor carrier goes to great lengths to make the broker shipper happy. It's important for the broker and shipper to refrain from putting unnecessary burdens on the motor carriers or the insurance provider. Concern, I know you haven't talked much, but that's your sugar pill, is it not?
That's exactly what it is. And I think that like we said, we aren't deterring carriers from doing a vetting process, brokers and shippers from doing a vetting process over their carriers, but we don't want them to ask for unnecessary things that aren't going to actually help them.
Because by making these requirements, the broker shipper then gains no additional benefit at the expense of limiting the motor carriers they do business with that are already qualified. So you're limiting your force here and gaining nothing out of it. The insurance sugar pill requirement for additional insured does not benefit any broker shipper involved and can only provide unnecessary roadblocks for the broker shipper use an otherwise qualified motor carrier. The white paper does not mean to deter the vending of the motor carrier. As the insurance says, you still want to vend them. But it's important not to get hung up on the titles or insurance requests, which at the end of the day do not matter when a crash happens. So thanks to writing the paper here, the white paper will be posted on the motor carrier's insurance website. You can download it. We suggest you send it to your motor carrier, and then do an agent of your motor carrier, then let them know they received the requirements to provide to their broker shipper when they're trying to explain it. If you have a relationship with a broker shipper, you want to share this information, both the webinar and this white paper, to that end. So in that part of it, Fred, and concern that we don't have here, we ended up on this white paper that we have your contact concern and the firm's contact, Fred, and also obviously motor carriers insurance education contact, hopefully to get the word out to everybody that will be from an unbiased situation to start this thing through. I'm sure that you would be more than willing to explain this to any shipper brokers that coming up this way. Is that correct?
Yeah, certainly. And I think it's important. Ultimately we want to educate the shippers and the brokers, but the first stage is educating the retail agents and the brokers and the insurance brokers for the motor carriers. And I think if we can do that, then that helps get the word out to everybody else.
Well, sir, I know we worked hard on this, Fred. I know that you let us do this. Thanks, Rob, and thank your firm for spending the time not only today, but work on this white paper. I understand that you're always going to put it on your website and push it out from your standpoint. And I've also got a couple of your lawyers that you deal with, the friends of ours who are willing to share this too. So this is available for everybody. We'll send it to everybody. You can download it from our website. Fred, Lauren, thank you. Stay safe with everything's happening here. I know you're working from home, and I appreciate you spending the time here. And I look forward for me being able to get back up to South Carolina. I miss my grandkids as well as miss you guys to go to lunch that we do all the time. So this is the end of this webinar. For more information, look at Motor Carriers Insurance Education Foundation here. This includes memberships only with designations, and you download this. Fred, Lucerne, thank you all. Y'all stay safe, okay?
Thanks, Tommy. We appreciate it.
Thank you.
No problem, guys. Thank you.